Forensics Tech Guy here. Please like, subscribe, and share my videos. It's important for the YouTube algorithms. Thanks. Now, let's get into the rhythm. Use your common sense. When you're sure you've seen or heard something, then realize it's not actually there. It can jolt you. It's called a visual or auditory hallucination, and it can seem like your mind is playing tricks on you. Don't believe fake news. In the case of Robert Sylvester Kelly, all we've seen and heard are years-long rumors. In a criminal trial, the burden of proof is on the government. Defendants do not have to prove their innocence. The defendant must be found guilty beyond a reasonable doubt, which means the evidence must be so strong that there is no reasonable doubt that the defendant committed the crime. Let's dig a little deeper about the burden and standard of proof in more detail. The standard of proof is the degree to which a party must prove its case to succeed. The burden of proof, sometimes known as the onus, is the requirement to satisfy that standard. In criminal cases, the burden of proof is on the prosecution, and the standard required of them is that they prove the case against the defendant beyond reasonable doubt. For the benefit of the jury in the Crown Court, this is usually expressed as requiring them to be satisfied so that you are sure of the defendant's guilt. This is unofficially described as the 99% test. It's not about what bloggers say or the news media or radio nor social media. What matters is what can be proven in a court of law beyond a reasonable doubt before a jury. Haters will hate. But, at the end of the day, it all boils down to what the prosecutors can prove. But, what happens if a witness lies, whether it's in a sworn affidavit or while under oath? The witness who intentionally lies under oath has committed perjury and could be convicted of that crime. The crime of perjury carries the possibility of a prison sentence and a fine, paid to the government, not the individual wronged by the false testimony. In the case of Azriel Clary, she gave a sworn statement and later changed her story after Mr. Kelly was in jail in July 2019. The defense will have cause to vigorously challenge her sworn statement when the trial begins, most likely claiming perjury. It will be interesting to see how this plays out in court. Can a defense attorney subpoena witnesses in a criminal case? The answer is yes. The defendant or his attorney can subpoena witnesses. What happens if a witness refuses to testify? Any criminal court may issue a subpoena for the attendance of a witness in any criminal action or proceeding in such court. If done properly, trying to interview prosecution witnesses can be an effective investigation technique. In addition to using court discovery procedures to obtain evidence from the prosecution, defense attorneys have a duty to investigate their clients' cases. Effective lawyers will gather evidence of their own in preparation for trial, and even to see whether the client has a reasonable chance of winning at trial. Leave your comments below.